All right, welcome everybody to the 2024 Legislative Action Committee post-legislative session webinar. We appreciate you being with us today just to follow up on those laws that were adopted this legislative session that impact the HOA industry and which will go into effect here in just a couple of weeks. So I'm Quinn Sperry. I'm currently the chair of the Legislative Action Committee, and we do have other members of our committee who are presenting today. And so we will move on into that because I know we want to be done by 1 o'clock because everybody's busy. And if we end a little bit before that, I'm sure everybody will be fine. And if we do end a little before, we'll have some question and answer period as well. If you do have a question while the presentation is ongoing, go ahead and put it in the chat. And one of us on the panel will, as we see that and we get to a break, we can then read that question. So we're going to start out with Tyler, who's going to be talking a little bit about SB 204. So Tyler, go ahead, and I will, if you need me to advance the slide, go ahead and tell me.
Okay, thanks so much, Quinn. Good afternoon, everybody. SB 204 was a bill sponsored by Senator Harper. Senator Harper has kind of become the HOA guy up at the Capitol. I was talking to somebody at legislative drafting yesterday about something that Lauren will present on here shortly, and they remarked how Senator Harper has become known in the community as the senator that addresses HOA matters. So this bill includes things that we advanced, but it also incorporates some requests from others to change the laws that impact our industry. And there are, but if you don't mind going to the next one, there are 6 different topics addressed by SB 204. I will be presenting on all of them other than water-wise landscaping. And then I'm going to present briefly on a new auto renewal statute that could affect management companies and others within our industry. So let's start out with corporate records. The change in the law is very technical, and I'm not going to spend a lot of time pointing that out. Instead, I'm going to focus on the substance of what the law kind of confirms. And I've created this chart. The Nonprofit Act and also certain provisions, as highlighted in yellow down there at the bottom, identify which records that an HOA needs to keep and produce to owners that request them. In the past, there was ambiguity in the statute that allowed for maybe broader requests. And there's been an effort over the last few years to clean that up. And including this year, some technical changes to the code allowed it to be further clarified to establish that there are permanent records, as identified on this chart, that must be kept. There's accounting records that must be kept. And then there are certain records that have to be kept at the principal office of the HOA. That's always been a little bit of a problematic concept for community associations because we don't necessarily always have an office space. But I would interpret that to be the manager, or if it's a self-managed community, either at the home of one of the presiding officers of the HOA, or perhaps even the clubhouse. So Quinn, if you don't mind going to the next one, I wanted to highlight that of the universe of records that we need to produce to owners that request them, there are a few that must be kept on the website if you have a website, and those are in green. So certain accounting records, the most recent of those accounting records must be kept, along with the governing documents, minutes of the member meetings, and then specific documents outside of the Nonprofit Act number 10 there. The reserve analysis and certificate of insurance should be kept on the website as well. If we don't, there's daily penalties for owners that wanted to get a copy and couldn't find those on the website. So Quinn, if you don't mind going to the next one. Okay. Next, let's talk about leasing restrictions. As you know, HOAs adopt a variety of different restrictions. Some people put in an outright ban. Some HOAs give a cap on the number of rentals. Some HOAs put in a restriction on a minimum lease term. Some do a variety of all of those that I just described. if we have a rental restriction, the code already restricted what we could request from a landlord. So items 1 through 5 were already in place. We couldn't require, well, actually, so we couldn't exercise control over the selection of renters, and we couldn't impose an additional payment or assessment. Now, there's a new exception, subpart 5, that came last year that allows us to collect up to $200 annually for actual HOA expenses if we allow up to 35%. Now the law restricts us from dictating a specific lease form for any given landlord. We cannot say if you have a rental, you have to use this lease form. Landlords have freedom of choice in the lease form that they use. And we cannot also exercise approval over their lease agreements. There is an exemption that we can require an addendum to the lease agreement that's provided by the HOA. So if you go to the next slide, Quinn.
Yeah, hold on just a second, Tyler. I don't know if I heard you wrong or not on that payment of the $200.
Yeah,
Just to clarify, it's you have to allow at least 35%.
yeah. If I said that wrong, as long as an HOA permits up to 35% of the units to be rented, then we can charge up to $200 annually for each rental unit to cover actual costs. That actual cost is typically going to be a charge imposed by the management company. Okay. So I mentioned that we can require that an addendum be used for a lease agreement of the landlord's choice. And here are some recommended provisions if you decide to require that an addendum be used. We recommend you include a provision that says that the tenant and the landlord will abide by the terms of the governing documents in the use of this unit or lot as a rental. We like to include a provision that shows and acknowledges that enforcement action can be taken by the HOA against both the landlord and the tenant and hold them jointly and severally liable. The act does provide that if we have a rule, but it's nice to have it in the lease agreement as well. We like to establish that if there's a breach of the governing documents, that constitutes a breach of the lease that may enable the landlord to take an eviction action as appropriate to address serious breaches of the governing documents. It'd be nice if they would agree in the addendum for us to be able to enforce the lease agreement, if you don't mind, go back one more time. And then just showing that any fees or costs that are incurred by the HOA as a result of the tenant's conduct or behavior, we like to say that that can be recouped by the HOA. So we'll distribute these slides, but these are some recommended things that you might consider including in your addenda if you are going to require that along with the lease form. Okay, perfect, Gwen. Thank you. Okay, we're going to talk a little bit about internal accessory dwelling units. So this graphic to the right depicts all different types of ADUs. Up at the top left, we show a detached ADU. We show an attached on a single family home. We show one above a garage. There's a basement ADU depicted. Our statute says that in a detached single family home project, and there are some limited exceptions that a city is allowed to adopt up to a 20% of their city footprint where this doesn't apply. But if the city has not done that, if it's actually go back one more time, Clint. If the city has not adopted an exempted area within the city's footprint, we have to allow internal accessory dwelling units that are if the lot is owner occupied in a detached home and the rental is for at least 30 days. Now, as the statute was drafted previously, it defined a rental lot as any lot that's used for occupancy by someone other than the owner. So if the owner occupied the lot, it wasn't considered a rental. And that means that even in an ADU scenario, because it has to be owner occupied, it couldn't be considered a rental. So what we did in 204 is to change the definition of rental lot in the Community Association Act so that it could pick up internal ADUs that we are obligated to allow. So if you go to the next slide, Quinn. So why does that matter? Why does the definition of a rental lot matter? Well, there's benefits to both internal accessory dwelling unit owners and also benefits to the HOA. It means that if it's considered a rental lot, it means we can't treat them differently because it's a rental lot. It means we can't charge extra fees because it's a rental lot, and that we can't require approval of the renter, just like we described in that lease restriction section. The benefits to the HOA is that we could limit the use of the common area because we've essentially doubled potentially the use of the common area by that lot by having two different residents or two different families potentially living there. We can charge fees if we elect to do so for the second use of the common area. So we could say, hey, the renter, if they want to use it, you have to pay an extra fee to use the clubhouse or the pool or the pickleball courts or whatever. And then we can hold them jointly and severally liable for violations. And then, of course, we could charge up to $200 annually for each occupant of a internal accessory dwelling unit.
And
so,
Tyler,
yeah,
real quick, that because we had a question come in on the chat that deals with that 200. So this $200 is what we were talking about before, right? Of if you allow at least 35% of the units to be rentals, then you can charge up to that $200, correct?
yeah. So, but Bill was asking,
Yeah, Bill.
can we charge some lesser amount if we don't allow 35%? And the answer is no, we're not allowed to do any fee because it's a rental lot. This was something we negotiated, and the give and take was to encourage us to allow more rentals. They're allowing the fee to be charged. This is the apartment association that has an exceptionally strong lobby. They're no longer called that. I think it's Rental Housing Association or something like that.
Yeah, and if we can jump in on that too.
Yeah.
That was negotiated a couple of years ago, just so everybody on here knows, and something that could come up. There was some other language that was in, or that we were talking about with the rental, the apartment association. Yeah, it has changed its name, but they want to basically state that HOAs cannot require leases for longer than 6 months, right?
That's right.
And so, many associations have 12-month minimum. They want 6. And so one of the things that we were saying was, well, if we're going to do that, then allow this charge to either be increased or get rid of the 35%. That is something that was not in agreement. And so as we got into the legislative session, all of that language was just pulled out, and that's an issue that we are still discussing with them as we will be going into next year's legislative session.
That's right. So Joni has asked, is it 200 per occupant or per unit? And it's on a per unit basis. It's on a per rental lot or per rental unit basis. So again, to recap, as long as you allow up to 35 or 35 or more, you can charge $200 for actual cost per rental lot or per rental unit, but not per person. Now, what I'm describing here in this slide that's displayed is if it is a rental lot, then the owner needs to choose, do I want to retain, and the HOA has some say in this as well, do I want to retain the right to use the common areas and give my tenant the right to use the common areas, like the amenities? If so, the HOA can charge an extra fee if both have the right to use it. Or the HOA could say only one of you gets to use it. And that's true for IADUs as well now with this cleanup and this change. We can say you got to pick either one, or if both of you uses it, we can charge an extra fee for the double use of those common amenities.
There is another question here, Tyler. I don't know if you can see it. Is there the ability of HOAs to prevent an owner-occupied unit to be limited, or to limit or prevent rental of rooms in their unit?
Yeah, that's actually a fairly common provision. It starts to get a little bit dicey because you might run into some fair housing constraints about what's considered a family. Again, there's limitations on what we can consider a rental lot. If someone's living in that unit that's the owner, it previously was not considered a rental lot. The question is whether this room qualifies as an ADU. It may. If it does, would be limited in what we can restrict. But it is a fairly common provision in CCNRs to discourage or restrict the separate rentals of rooms if it's not an ADU, if it doesn't qualify as an ADU.
Yeah,
So
to clarify, any of the HOAs where it's attached, right? Shared walls, this internal accessory dwelling unit law does not apply. They have to be detached homes for them to be able to rely upon this law for the internal accessory dwelling units. But I agree with you, Tyler. If it's a detached home, the owner occupies it and they want to be renting out rooms, you would have to look at this. And if it's qualifying as an internal accessory dwelling unit, we would not be able to prevent that.
And I think that may be difficult in most cases if you're just renting out a bedroom to qualify that bedroom as an ADU. If you look at the requirements that they're obligated to get through the city and some of the code requirements and everything for ingress and egress and access, it most likely would not be considered an ADU. But in concept, it could be, and if it was, we'd be limited in restricting it. Okay. Bruce has asked, are there rules applicable to our rentals if we only allow 25% of our units except for the $200 fee? It's perfectly acceptable to have a rental restriction that only allows 10% or 25% of the units to be rented. That's enforceable in Utah. We can do that, and there's no problem with that, other than you won't be able to charge that $200 fee. Other than that, it doesn't matter if it's a 50% restriction, a 35%, or a 10%, everything's treated similarly. You get to choose. There's just now an incentive to allow up to 35%. Okay. Any other questions on this rental question? All right. I'm going to skip over the water-wise landscaping because Lauren's going to present on that. And I'm going to jump to relief from taxation of common areas. At times, this is very simple. We're not going to take a lot of time here. It seems self-evident and obvious that common areas should not be taxed separately from the units and lots. However, we get a lot of complaints that there are certain counties, Wasatch County in particular, that taxes each unit or lot owner and then sends a separate tax bill to HOAs. And contesting those tax bills is confusing for HOAs, and it's expensive to hire counsel to fight with a county assessor's office over taxes. We've been working on this one for several years, and we determined that there needed to be additional clarity in the code section that assessors turn to in determining how to tax common areas. So all we've done here is to further clarify what we believe has been the law all along, and to clarify in a way that a county assessor's office cannot mistake that HOA should not be getting a separate bill for taxes on common areas. Instead, the value of those common areas should be allocated to each lot or unit owner and included in each lot or unit owner's private tax bill. So if you manage an HOA or you're on a board of an HOA that's getting a separate tax bill for common areas, you should look into this one a little bit more and see if there's a basis to push back. There almost certainly is, because we've helped clarify in a way that we hope will discourage county assessors from this practice that we believe results in double taxation. Okay. I did see another question come up, though, I think.
There was one, I answered it. It was,
okay, perfect.
I mean, I'll say it out loud. It was, does that $200 fee only apply to detached homes? So to clarify, that the $200 that can be charged is any community if you allow at least 35% rentals. That's completely separate from the internal accessory dwelling unit. The law that's stating you have to allow the internal accessory dwelling unit to be rented or allow them to have that if they're finding that protection, it applies only to detached homes.
Yeah. And so to clarify too, previously, before this new change, we could not have charged the $200 on a internal accessory dwelling unit rental because our code did not consider that a rental lot because the owner lives there. By definition, an internal accessory dwelling unit is owner occupied, so it could not be considered a rental. Now it can, even though the owner's living there in the same footprint of the dwelling, it can be considered a rental, so it can be counted along with that. Okay, lastly, I'm going to present briefly on the transfer of common area. Back in 2017, Bruce Jenkins headed up a really important and helpful section, an amendment to the Land Use Development and Management Act that enabled HOAs with city approval and with 67% of the ownership vote to sell a portion of their common areas. Prior to that change in 2017, an HOA could not sell or transfer their common area except to the city. And this has been very helpful for some associations that have land that they don't use or that's a liability. I had an association that had an old dilapidated swimming pool, and it was going to cost a fortune that they didn't have to get this pool up to code and operational. And the population of this community had aged, so they were no longer using the swimming pool like they did 30 years prior. This new law enabled this association to sell the pool area and the land around it to a developer, and they were able to replenish their reserves, which were underfunded from years of artificially low dues and from years of maintenance neglect. So it ended up being an amazing opportunity for this HOA to sell it. Well, that 2017 law maybe left a few things unresolved, specifically the issue of what happens to the easements on that land. This gets kind of technical. We're getting into some technical property law principles here. But it's one thing to be able to sell land to another. That doesn't necessarily extinguish the easements that people own for that land. So HOA members all have an easement to the common area. The common area has been sold. You arguably still have an easement to that parcel that was sold. So the intent of this statute was to extinguish that easement, that if an HOA goes through the process of obtaining 67% approval and city approval to transfer land to a third party, then the owner's general easements in that land are extinguished. Now, I think there may be some work to do on this to further clarify this, and that's often the case. We work with legislative drafters, and sometimes they follow our recommendations. Sometimes they put their own style on it. And Quinn, I think you would agree, we might want to revisit that to further clarify. But the intent of this, as confirmed through the sponsors of the bill and even the drafter, is to allow an HOA to transfer land and then simultaneously extinguish any general easements that exist in that land. Yeah. Okay, so
hey,
Thomas.
Tyler, real quick before you go on to the next thing, another question came in back on the taxation of the common area. It says, do the tax bills of the owners then go up once the county backs down on taxing the common area?
No, they shouldn't. So what's supposed to happen is the county is supposed to set a market value for each property. And we believe that all counties have been doing that basically appropriately. And there's an opportunity to challenge that if you think they've gone too far. So in the counties where we see this, they're already setting the market value. And that market value is supposed to consider the number of rooms, the year it was built, when it's been updated, and also access to things like common area pools or clubhouses and things like that. So that should already be factored in to each property owner's tax bill. So when they came and gave a separate tax bill to the HOA for the common area, that's just a surplus, a windfall to the county, because they've already captured that market value in each unit, and then they're double dipping by sending a new market value for common areas. It doesn't make sense to set a market value on common areas that hasn't been approved for sale by the city or the owners, because there is no market value. It can't be sold or transferred. So that's the reason why it shouldn't have been done in the first place. And most counties get this right. Most counties do the right thing and they only send the tax bill. But some assessors have been stubborn, and this is our effort to get them in line.
Yeah, it was done to eliminate the double taxation that was occurring in some counties.
That's right.
Yeah.
So Thomas asked a question, is extinguishing the easements retroactive to sales before SB 204? I don't know the answer to that. Quinn, do you know the answer to that? I don't know.
Say it again. I didn't see where that answer or that question came in.
Okay, so Thomas.
Oh, I see it.
The
Extinguishing.
question is,
Okay.
hey, we had some sales occur prior to SB 204. What happens to the easements in that case? And I don't know if we had retroactivity language in SB 204. Do you recall, Quinn?
It does state that it applies to every association, no matter when it was created.
Okay.
It doesn't expressly go in to state that
When the transaction occurred or something.
Yeah, and so that is, I think what you've got is then kind of some of your other just property laws, right? I mean,
Yeah.
So it's
So yeah, it sounds like there could be some transactions where that could be somewhat of a messy issue. I'll tell you that when we first encountered that argument that there were remaining easements, it felt like a novel argument. It felt like, well, everyone understood this differently, that everyone kind of understood that the 2017 law was allowing a full transfer and that would take it out of that common area easement regime. So there are arguments still to be made, and we don't have case law on this to my knowledge. So Thomas, to answer your question, I think we don't have an answer. So we'll have to wait and see if someone truly litigates that, what the courts would say.
Yeah, I think some of the arguments are also, the CC&Rs allow for amendments to happen. The CC&Rs, they're the document that grants the easement to the common area. And so when you're changing that, and they have the language of how it's amended. So then as you go through and you amend the documents, especially amending the plat, and then selling that off, then that would in effect extinguish those easements. I mean, I think that's what the understanding was. It's just as that argument was brought up, then it was, well, let's make sure that that's clear in the code. There is a case up in let's see, Heber, the equine holdings case, that does talk about amending the plat. I mean, they're amending the location of the common area, and so that does touch on the issue of the members can amend the plat and the location of the common area, modifying the size and location, and how that impacts the members' easement rights. And so I think if you're able to take the reasoning in that and apply it to this, there is a really good argument to say prior sales extinguish those easements. And now this is just codifying that principle.
Awesome. Thank you. That's kind of getting super technical, but for any associations that are thinking about selling common area, it should be a helpful tool and helpful clarifying tool. Okay. Lastly, I wanted to look at HB 174. You are already probably familiar with the existing Service Contracts Act that has limitations on auto renewals. Certain contracts required special notices to be a valid auto renewal. And even though we already had a law addressing this, Cheryl Acton in HB 174 adopted an additional auto renewal restriction that applies in Utah. Now, if you go to HB 174, they have an exemption for property managers. But the definition of property managers is the definition that relates to those that are overseen and regulated by the Division of Real Estate. And it does not apply, and HOA property managers are exempted from that regulation from the Division of Real Estate. So the exception for property managers, you might read that and think, oh, this doesn't apply to a property manager's contract. I believe it does, because HOA managers are exempted from the DRE regulation. They don't have to be overseen by a broker, or they don't have to be a broker either. So HB 174 has a few different provisions, but what I wanted to highlight for you is how it's very punitive. The Service Contracts Act simply says it's not enforceable if you don't follow these steps. HB 174 says if you try to auto renew without following the steps, you could be facing penalties from the Division of Consumer Protections of up to $2,500 for each violation. And if they have to bring an action against you and get an injunction, they could get their attorney's fees, their court costs, and investigative fees. That is exceptionally concerning for me. What are investigative fees? I don't know how those are calculated. I've never been involved in litigation to determine what reasonable investigative fees are. Does that mean we're paying for the wages of the personnel at Division of Consumer Protection? I don't know, but that concerns me. You also, if you violate a court order under this section, you could face up to a $5,000 fine per violation. So it's one I think to take seriously. If your contracts, if you're operating in this industry and you have an auto renewal provision, take a look at HB 174. If you go back, actually, Quinn, one more slide, the previous slide, you need to give, do I not describe it here?
I don't think so. That's it.
Okay. Take a look at HB 174. It's similar notice requirements, but they are not exactly parallel to the existing Service Contracts Act.
Have it right there.
Oh, there it is up
Right
the top.
there at the top.
Yeah. You got to provide at least 30, but not more than 60 days before the auto renewal provision kicks in. Clear and conspicuous disclosures about the renewal date, the total renewal cost, which is a little bit ambiguous, and options for cancellation of the contract. So beware of that if you're using an auto renewal provision. Okay.
Okay, thank you, Tyler.
Thank you.
We're going to go ahead. I know you had a lot to cover there in 204 and the auto renewal. We're going to go ahead to Barry on HB 104 with the radon mitigation.
Thanks, Quinn, and thanks, Tyler, for all your work. So HB 104, we talked about in the previous meeting. There was a slight change in what was actually adopted, but it limits the homeowners association's ability or authority to adopt or enforce a rule that prohibits an owner from making modifications for radon mitigation. That's, as you know, a safety issue. We don't want to stop somebody from living safely in their unit. But here's the actual language. So rule, except as provided in this subsection, a rule may not prohibit a unit owner from making modifications consistent with industry standards for radon mitigation. Subsection 11A does not apply if the modifications would violate a local land use ordinance, a building code, a health code, a fire code, and then a rule governing the placement or external appearance of modifications may apply to modifications for radon mitigation unless the rule would unreasonably interfere with the modification's functionality, or this is the thing that changed between the last meeting and this meeting, it would add more than 40% of the modification's original cost to the cost of installing the modifications. And so, again, this is just a rule. An association can adopt a rule, but not if if that cost exceeds more than 40%, for them to relocate that radon mitigation system. And so in the last meeting, we talked about the average cost of installing one of those systems is about $2,000. So 40%, you're looking about $800. So if it's going to be more than roughly $800, then they are permitted to put it in where they initially wanted to do that. The next thing was a rule may require that a unit owner making modifications related to radon mitigation first demonstrate or provide proof of radon contamination and provide proof that the modifications and any related construction will be performed by a licensed person. And then the most important part, a rule shall be reasonable. I think we all know that. So in summary, this bill wasn't designed to prevent people from being safe or prevent them from putting in radon mitigation systems. It's really designed for an HOA to determine what's appropriate for the installation of radon mitigation systems in their communities. If the board feels like it's okay to have those pipes down the front of the unit, that's up to them to make that determination based on their rules and their ability to adopt and enforce rules. But to adopt and enforce a rule that's going to exceed that 40% number of the original cost, that's where we run into an issue. We can't make it exorbitant, the cost for them to do that. And that's the whole purpose of that 40% was we want to make sure it's put in appropriately for a community. It's put in the right place within reason. I don't know. It seems to me that the people I've talked to, that $800 is in a lot of cases sufficient. But I'm sure in a bigger unit that is in a bigger building, that may be a little more difficult. So I think that's the last slide I had on that, isn't it, Quinn?
It is. And
Okay.
Let me make just a couple of comments, and then Bruce Cutler, I see your hands raised, so I'll allow you to talk and make your comment as soon as I'm done here in a second. One thing to just put a plug in for what we do as LAC with our industry. I mean, when this bill was first introduced, it was really just you have to allow anybody to put in the radon mitigation systems, no controls, nothing, right? And so we obviously understand if it's a health issue where you need to allow that. And it's one of those where we see that the legislature was going to be pushing for this. It had some backing. And so we had to work with them to get some protections in place, not just for the homeowners who want to mitigate the radon, but for everybody else, right? And that's where the 40% of the modification or the costs issue came up. And then also putting some restrictions where they have to at least demonstrate that they need it, and then requiring that the mitigation system be put in by a licensed person. And so, and again, that's to make sure that as it's installed, that it's done in a way that's not allowing water to then penetrate into the exterior of the building, right? In those common area walls or roof, which can then create even more long-term defects or issues for the association. So again, working with them to find the balance to allow the people to install the system for their own health, but also having it done in such a way that protects the structure of the building and everybody else. Bruce, I'm going to allow you to talk, but you put your hand down so you can tell us if it's over. Go ahead if you need to.
No, that was my mistake. I'm sorry.
Okay. All right. Okay, that's it. Let me see if there's other questions right now. Okay, we'll go ahead. Thank you, Barry. Moving on to Lauren with WaterWise landscaping changes. You got a couple of different bills to cover here, so go ahead.
Yeah, good afternoon, everybody. If you'll advance that slide forward, Quinn, appreciate it. As Tyler indicated, SB 204 did have some WaterWise provisions. As it pertains to the Condo Act, SB 204 added definitions for WaterWise landscaping and WaterWise plant material that mirrors what we previously added to the Community Association Act. It also directs associations to adopt rules pertaining to any area for which the landscaping is maintained by one or more owners. Does that apply to an association? I don't know, probably not, but I think it's a little bit vague. These rules have got to allow low water use during drought conditions. Thanks, Quinn. but you can have design criteria for the water-wise landscaping and limit your permissible plants to water-wise plants only. It also restricts a condo association from prohibiting low water use during drought conditions. So really a huge focus on limiting our water usage. As to the Community Association Act, the SB 20, whoa,
Sorry.
cruising through. Not that fast of a talker. SB 204 amended the Community Association Act in a similar way. So any area that the landscaping is maintained by one or more lot owners, whether it's within a lot or common area, the association needs to adopt these water-wise landscaping rules, allowing for low water use during droughts, allowing for design criteria to support water-wise landscaping in our communities, and getting that permissible plant list down to water-wise plants. Now you can proceed forward. The water-wise amendments of SB 204 mostly also change definitions. You'll see a bunch of strikeouts if you look at the law, because previously it used water efficient landscaping, which was not a defined term. So probably, you know, a considerable chunk of what we changed was just to clean up to get the same defined term used throughout. You can move forward, Quinn. Now, SB 204 previously had a deadline for associations to adopt water-wise rules. It was June 30th of last year. And that deadline came and went, and most associations didn't even notice, but there was no penalty for failing to adopt those rules on time. So now we do have a penalty and we have a notice process. So this is going to look just like your open meetings violations, where if an association hasn't adopted those water-wise landscaping rules, an owner can give a 90-day notice, at least 90 days, provide them with the requirements of the water-wise landscaping rules, and the board has some time to take some action, get those rules into place. If they don't, then an owner can bring a lawsuit and seek $500 in damages, or their actual damages if there are any, attorney's fees and costs, and also get injunctive relief, an order requiring the association to adopt those water-wise rules. So there is finally a mechanism for some teeth to push this forward without an arbitrary deadline, and, you know, poor notice to all the associations. So I think this is going to be much more effective going forward.
And Lorna, we've had a couple of questions come in. I mean, I'll kind of summarize them. One, if the association does all the watering, all the landscaping, do they need to adopt these rules to allow for water-wise landscaping?
Yeah, it looks like Tyler is coming up with an answer there. He probably will type a more beautiful answer than I'll tell you, but these SB 204 uses the words one or more owners. So if this area is maintained by one or more owners, I would take that to not apply to associations. You know, of course, I think we should encourage our associations to adopt water-wise rules, but at the same time, we probably don't want as strict of limitations on parks and playgrounds. You know, we still want to have some grassy areas protected. Do you agree, Tyler? Okay.
Yeah, and I'll even say, I think the intent here was, like last year when that law went into effect, people were saying, well, if the HOA does all the landscaping, why do we have to adopt rules, right? Because then that implies the owners can come in and change the landscaping. And so again, what you were saying, Lauren, is I think we should always be cognizant of how much water is being used and looking to see, even if the HOA takes care of all of the landscaping, all the watering, looking to see, are there ways that we can conserve? And right. But now the law doesn't require them to go in and adopt these rules if they're in charge of it all. If you have any of the unit owners, lot owners that are in charge of any of the landscaping, then the HOA does have to adopt these rules. And so that's what it was. And then there was the other question of, well, I missed it. I think Tyler answered it.
Yeah. So the other question, and Lauren, this would be good to get your feedback, is what if you have a community that already is water-wise? So let's say it was already kind of drought resistant plants and low turf all throughout. The question was, does the association need to adopt rules in those kind of communities for owners that already have water-wise landscaping within their control?
If it's not written or memorialized somewhere, I would say yes.
I agree with you.
Yeah,
Because
I
what
agree.
if somebody wants to make a change, right? What if they want to change it, or what if they want to go to less water wise or even more water wise or reconfigure it? I don't think there's an exemption for already water wise. I mean, water wise has a big range too. I mean, it could ever be everything from eliminating grass by only 5% to having no grass, right? So I think it applies to those associations regardless.
Well, and on that point, Tyler, is somebody saying they want to make a change. One of the updates in the law this year was, with last year, it was you just have to allow the water-wise landscaping, right? It was vague on whether or not they could dictate, okay, it's within the scope of water-wise plants, you can use these plants to make sure that we have consistency in the community. Now the statute does allow the association to have some of that design criteria to make sure that we're helping maintain the aesthetics in the community as well.
Right. So HB 275 ended up having another water-wise effect to the Community Association Act, which does not really comport with SB 204. So previously, an association couldn't require a lot owner to have turf or grass covering more than 50% of their yard or in an area of less than 8 feet wide. So, park strips, that sort of thing. In committee, I guess, HB 275 was amended to delete all of that nuance of where you can't require turf to just say you can't require turf or grass. So Tyler has talked to legislative drafting because this does conflict with SB 204. Unfortunately, Tyler has indicated to us this morning that it sounds like deletions, at this point, legislative drafting thinks that deletions will take precedent over amendments, meaning that come May 1st, associations won't be able to require owners to keep, maintain, install grass or turf at all.
Yeah, can I just share, this is exceptionally frustrating for me as a LAC member, because we spend so much time monitoring these bills. And when HB 275 was first published, it had nothing to do with the Community Association Act or the Condo Act. And I think Lauren was the one that found it and flagged it. I can't remember exactly, but we reviewed it and we said, okay, this HB 275 is just focused on municipal grass areas. It doesn't affect us. So we've got to be prudent in how much time we spend and showing up to committee hearings. Unfortunately, we can't hang out at the Capitol all day and sit in on a hearing. But what happened is at this hearing, an amendment was made that was not previously published that addressed our act. So now we have two bills that amend the very same section of code. And when I flagged this for legislative drafting, it actually got a good chuckle, and they said, well, it's on our list to try to reconcile, and they have a series of rules about what to do when two bills amend the same section of code. But the indication, unfortunately, for our industry is, for now, we'll be left with this kind of poorly crafted statement that an association may not require installation of lawn or turf in an area. So
Yeah, which we're all asking, we're all saying.
What does that
in
mean?
an area, yeah.
Legislative drafting said, hey, my read on that is you can't specify the area. You could still restrict lawn or require lawn, but just not to a specific area. That just sounds like a recipe for lawyers to make a lot of money and for everyone to be frustrated. So
Yeah.
I think we should address this next session and go back to what SB 204 did, if this ends up being the prevailing language.
Yeah, which we'll know, well.
Oh, in May, yeah.
Yeah, in a couple of weeks when it's supposed to take effect, and they should update the laws. So we'll know that in a little bit. But okay, let's see. You had one other thing there. Lauren.
Yeah, last one, this was on our list and we had been watching it, but it doesn't really directly affect our industry. For schools, school districts and municipalities, overhead irrigation is really going to be restricted in the Great Salt Lake Basin drainage areas, which will include Bear Lake, Bear River, the Weber River, Jordan River, Utah Lake. So overhead irrigation won't be allowed for park strips, areas less than 8 feet wide, an area that's not a planting bed, except for active recreation areas. So schools will still be able to have, soccer fields, and that sort of thing, but they won't be able to classify all of their property as an active recreation area. The law is very specific about that. Similarly, highway authorities are not going to be able to install any landscaping that will require overhead irrigation or sprinkler use on the sides of roads, in roundabouts or medians. So I think you'll start to see this, most populated area of the state becoming much more desert-scaped, much more xeriscaped, with a lot less lawn and turf being installed going forward.
Yeah, and again, just to reiterate, you said it doesn't apply to our industry right now. But just like the last bill that we just talked about, we want to be cognizant of this to see what's happening, because the last bill started out with just municipalities, and then all of a sudden it ended up, impacting HOAs. So,
Well, I'll say, if you look at the votes on HB 275, every senator that was present voted affirmatively to it. Basically, any water-wise bill that goes up is supported, almost as a presumption it will be supported. So we're going to have limited negotiation power, I think, in pushing back on water-wise restrictions.
right. So, okay, I know we're trying to be done at 1, which is 4 minutes, and I've got our last topic, and so I'm going to be cruising through this. Not much has changed since our last meeting. This is on the Corporate Transparency Act. Again, this was a law that was actually adopted back in 2021. It did go into effect in January 1st of this year, the reporting, and it is the intent of the law is to try to impact or prevent laundering of money, right? It's an anti-laundering, anti-terrorism funding act, which we look at and say, I don't think too many HOAs are doing that. And I'll get to that at the end of what we're doing. But so what exactly is it, and who has to comply? So the types of entities that have to comply are, various businesses. You can basically say any of our community associations, condos, associations in Utah will have to comply with some very limited exceptions. Okay, if you're a very, very large one, you have more than 20 full-time employees and gross receipts or revenue in excess of 5 million. So if you satisfy both of those, you would be exempt from that. That's probably not happening. Even the large ones here, even though you may have more than 5 million in revenue, you may not have 20 full-time employees, especially if you have a management company managing. It's their employees, not yours. So just, for most, you're going to have to comply, which means you have to report certain information about beneficial owners. And that doesn't necessarily mean that it's the people who own it. It's people who have at least a 25% ownership interest, or they're in a control group, either directly or indirectly. So if you're on the management committee, if you're on the board, you will fall within the scope of that control group. And so you do have to report, and the information is reported to the U.S. Department of Treasury. And like I said, it's a 51 question report. This is a hyperlink that you can go to fill it out. Information that you have to provide about those beneficial owners is on this list: full name, date of birth, address, that can be your business or residential, and then an identifying number, which can be your social, driver's license, passport, or if you don't want to give any of those out, you can register with FinCEN and get your own identifying number for FinCEN. But I imagine if to get that, you have to be providing them with that other information anyway. So our main concern here is that this can have a chilling effect on people who are willing to serve on the board. It's already difficult to get people to serve, and now this, people knowing that they're going to have to provide this information may make it even more difficult. If your association existed prior to January 1st of this year, and not just, we're meaning the entity, if you were registered as a corporation, most are nonprofit corporations, prior to January 1st, then you have until the end of this year, really until January 1st, 2025, to file your registration. Those companies, entities that were incorporated after January 1st of this year, you have 90 days. And so some of them that were incorporated right at the beginning of January, you're already there. And then after your initial registration, if any of that information changes, so changes in board members, you have 30 days to update that information. If you fail to comply, there are penalties, $500 per day, and as well as criminal penalties. I think it had to be pretty extreme for anyone in an HOA to have criminal penalties, but that is what's happening. So our national organization is working on this issue. Michael Johnson, you put some comments there, and so they are working on an exemption. This would be the best thing for HOAs to just be completely exempt from this reporting. We're also looking at a delay. Right now, the proposal is a 1-year delay, and that is there's already a bill in the House back in Congress that has been passed. We need the Senate bill or the Senate to also approve that, and so we do want you to reach out to your senator on that. And then one other thing that came up is on March 1st, you had this federal district court in Alabama that ruled that this Corporate Transparency Act was unconstitutional. The government appealed 10 days later. The government has appealed and issued its notice that all other entities still have to comply, but they will not be enforcing this act against the plaintiffs in that case. I think we can all assume that there will be other lawsuits that will be popping up and challenging this. And I think the hope is really, is the more challenge that we see in the legal process, that puts the pressure on Congress and really the Senate to then also adopt the bill that delays the implementation of this while it gets worked out, while we look at further exemptions. And so again, if you can reach out to our Utah senators to get this rule adopted to delay the implementation, that is what we would love, so that again, we national can be working upon an exemption completely for community associations going forward. So if you want to stay up to date on this, the National CAI has a blog where it's posting updates, and so you can go to that URL and get updates. And then finally, with us with LAC, again, as we go out and we are up at the legislature and looking into these things, it is we have a lobbyist, but it's also the important thing of supporting those representatives in our state legislature who are aware of HOA issues. They listen to us, and so we want to be supportive of those people and get people in to understand our industry and listen to us. And so we have established a PAC that we're asking people if you can donate to, in communities, be supportive of this, knowing that the laws do impact you. Advanced Community Services has already put up a $10,000 matching grant. So again, we're trying to get the word out, get people to donate so that we can raise that to again be supporting our efforts. So anything else that other panelists would like to share as we go into the Q&A? And I'm just looking back if there's any other comments that came in. Okay, Lauren, looks like there were a couple water wise that you're responding to there. Some others. Okay, Bruce is asking when we'll receive the slides. So yeah, if you would like to receive the slides, Stacy, if you're fine, if they send you an email, you know, you would have had that on your registration information, or at least your invite, respond to that, and Stacy, you can send out those slides, right?
Yep, thank you.
Okay. Okay, anything else that anybody else would like to comment on before we're done? Okay, I'm seeing, at least on the comments, looks like most of those have been addressed. And the questions. So there is one more here. Any discussion within LAC about enacting a law to empower boards to adopt resolutions allowing for the dissemination of notices through alternative channels such as websites and email? Some older documents restrict notices to mail only. Some even say by telegram. Yikes. Which can be burdensome and expensive to the association. It would be beneficial to have legislation enabling boards to make this change without having to go through the amendment process. Lauren, do you want to comment on that, or?
Yeah, I think we have some reasonable notice provisions in our acts and in our Nonprofit Corporation Act. And I think websites and emails could potentially be reasonable if they are reaching the owners. That's the issue. If you don't have a complete email list or people aren't checking the website, that becomes an issue of perhaps unreasonable notice. I have a condo community that has a website that no one ever checks. And so that just, I wouldn't consider that to be reasonable notice. But if you've got a community that is adapting to these alternative and new methods of communication, I think that that's a legitimate way to communicate.
Yeah, I think the important thing there is the Nonprofit Act does incorporate, you know, technology and allowing it to be done through electronic means. And so there's always the question of, is that statute going to directly, you know, supersede the language in your documents? I think that's one where you've got to discuss as a board, and I would suggest getting the association's attorney there to give you an opinion on what your options are. Because the best thing is to go through the amendment process. I understand that can be difficult, but then if you can't do that, if you just can't get the support, I think that's where you look at those other issues, and the attorney can advise you as to any risk that may be involved given the language of your documents. So, okay. Yeah, I asked about a recording. Yeah, the recording of the meeting and the slides, go ahead and reach out to Stacy on that. Looks like that's all the questions. We're a little over time, and so we'll go ahead and end. Thank you for everybody who participated.